Hiya, Paul Cardin here from the We're All In It Together WordPress blog. This video is about the Freedom of Information and Personal Data ban on me by Cheshire West and Chester Council in 2009, which lasted for 20 months. Just over 10 years ago, I lost my job at Cheshire West and Chester Council. I was a street lighting design engineer and had worked there for about 5 years. I was targeted and eventually forced out after speaking up and lodging what was known as a dignity at work complaint. In the end, the council recorded the loss of my position as a voluntary redundancy, but nothing could be further from the truth. This complaint had needlessly turned into a long-running dispute between me and the council, one which was relatively minor and which could have been nipped in the bud very early on if they'd had the foresight to do that. But the middle managers and later the senior directors, in their wisdom, decided not to act on it correctly and instead doubled down whilst feigning support, ignoring my complaint and turning all their firepower back onto me. Ultimately, I ended up receiving a range of bogus gross misconduct charges, which were all sackable. They began gaslighting me as a troublemaker, as though I was the problem, and they'd satisfied themselves that my removal would be the correct solution. But having been through a similar situation before at neighbouring Wirral Council, I was more than prepared this time to fight fire with fire and to not allow them to get away with sacking me so cheaply. My well-being was never really a concern for them, and as time dragged on and I hadn't backed down or budged, they began fearing a loss of face and took the predictable step of doing everything they could behind the scenes to avoid reputational damage to the Cheshire West and Chester Council brand. Initially, management regarded me as an inferior, which I was professionally. I was a lowly lighting design engineer, but they personalised it, played the man, not the ball, and made the mistake of assuming I was an inferior human being as well, somebody who they could easily bully, gaslight and sweep to one side. And they were fully prepared to gang up and ruin mine and my family's health into the bargain. Okay, I did go off sick with stress and I took gardening leave when it was offered, but their confidence in achieving their malicious ends had been severely misplaced. I wasn't going to allow them to turn me into an empty shell of a person who'd be desperate to settle for anything. So as it progressed, I used their own finely worded policies and procedures against them, and I stuck to them rigidly. In these kind of disputes where the management response is a fake one, this approach is absolutely essential. The longer I focused on the correct way of doing things, the more it exposed them and revealed to the impartial observer that the council, unlike me, were fouling up and making regular and frantic departures from their own procedures in their desperate desire to be rid of me. Frankly, they were wildly inconsistent, all over the place, breaching policies left, right and centre, and were botching the whole thing very, very badly. Due to management's blind intransigence, the dispute itself lasted 2.5 years, and to cut a very long story short, it all ended in a final hearing at Cheshire West Council's old headquarters building in Chester on a beautiful sunny day on the banks of the River Dee on the 21st of August 2009, which happened to be my 50th birthday. And now we're coming to the substance of this video, the reason why we're going to go public on it all over again. All the bogus charges fell to pieces around them as I secured victory. The penny later dropped for me why they'd waited until my 50th birthday to conduct the final hearing. At age 50, I would become eligible for my work pension. The UK government later upped this qualifying age to 55, but luckily for me in August 2009 it was still at age 50. They knew they were in possession of a very weak case all along, but because my own reputation had been trashed internally by my line managers and their colleagues, win or lose, I could never go back to my job working with the same people. I couldn't be redeployed either because my street lighting design skills were far too narrow and specialised to transfer across to any other area. So the council, perceiving they were likely to lose, had a very good bargaining chip in the shape of my 32-year pension, which could now be released if they couldn't get away with sacking me. So it took on the role of a bribe, one which could be used to buy my silence and deter me from making personal data queries and freedom of information requests for important information and data. Details which would reveal sensitive and potentially incriminating aspects of their behaviour during the dispute. So when they did lose the case, they made me sign a compromise agreement to shut me up. They described this as a mutually agreed full and final settlement that would draw a line under the case. I would then leave my job on the agreed terms set out within the agreement. However, there was an important clause added to it, and this is the whole point of this video, one which they had never used before on anybody. This clause was set out as follows. Clause number 10.2. Insofar as a valid request is made under the Freedom of Information Act 2000, the employee agrees to provide a reasonable cooperation to the employer to enable it to deal with such requests. The employee agrees that he will not submit any request made under the Freedom of Information Act 2000 or the Data Protection Act 1998. So essentially the council was seeking to have me banned from exercising my statutory querying rights under both freedom of information and my personal data. These querying rights are basically set in stone for every adult living here in the United Kingdom. I was forced into signing this because I'd driven a hard bargain, won the release of my local government pension, which had started at age 18, and been transferred subsequently from the Royal Navy to Manweb, to Wirral Council, and finally to Cheshire West and Chester Council. I didn't want to turn down this pension and risk losing at a subsequent employment tribunal, because it's a broken system which I did not trust, and one I and many others see as being skewed and heavily biased in favour of corrupted UK employers. But I knew then that I would need to carry on fighting the council in order to recover my statutory rights, because I knew their conduct had been unlawful. As time passed, I discovered that the Information Commissioner viewed the ban as a breach of my human rights. So I was determined now to overturn the council's foolhardy decision and make them regret their actions on this. I contacted a top lawyer called Hugh Tomlinson QC, who agreed to act on my behalf on a no-win, no-fee basis. Hugh Tomlinson wrote a very brief legal statement addressed to the council, which I will read shortly. I previously covered this story on my blog under the post entitled Opinion of Senior Counsel Hugh Tomlinson QC on Freedom of Information Ban by Cheshire West and Chester Council. And you can look that up on my blog, we're all in it together. Following Cheshire West and Chester Council's hideously misconceived ban on my statutory FOI and personal data protection querying rights, the time has come to release the opinion of Senior Counsel Hugh Tomlinson QC, who was granted his permission. This ban lasted for 20 months, between October 2009, which was my leaving date, and June 2011. In the description box below is a link to the original Freedom of Information request I made. It took an instruction to possibly the country's most senior privacy lawyer for the council to realise its behaviour was ultra vires and it had gotten too big for its little boots. The ban flew in the face of the council's own internal freedom of information and data protection policies, and certainly every other council's policies up and down the country. These are always phrased to embrace accessibility, to promote openness and transparency, and to speak up for the free and uninterrupted flow of information. However, the council's most senior data protection person on site, who understandably had a large hand in drafting council policy, admitted to me in a phone call that he was never consulted over this defensive and retrograde step. Neither was this ban democratically scrutinised by elected councillors, possibly because there was a danger elected officials may have taken their role seriously and raised a red flag upon spotting the folly of it all. So it became the private back office unscrutinised work of the monitoring officer Simon Gocher and his team, as trotted out in an email heavy on the flannel from Councillor Alan Mackey, chair of the staffing committee. Despite the council's lofty public claims to democratic accountability, when a ban on freedom of information and data protection became a necessity in their eyes, the legitimate and compelling public interest never really got a look in. The council have now claimed, in response to a subsequent FOI request of mine, that no information is held on this subject. With that, the obvious question arises: why on earth did they feel the need to ban me in the first place? And now into the mix comes Hugh Tomlinson QC's opinion, which gives clarity and makes an important distinction between historical and future requests. For me, the key statements are made in paragraphs 5 and 6. And here it is. Hugh Tomlinson's opinion, dated 31st of May 2011. Number 1. I am asked to advise Paul Cardin as to the merits of a proposed claim against Cheshire West and Chester Council arising out of a compromise agreement dated the 1st of October 2009. Mr. Cardin seeks to challenge a clause of the agreement which purports to restrict his ability to submit requests under the Freedom of Information Act 2000 and the Data Protection Act 1998. The second sentence of the clause, 10.2, provides that the employee, this is number 2, the employee agrees that he will not submit any request made under the Freedom of Information Act 2000 or the Data Protection Act 1998. I am instructed that this was not specifically negotiated between the parties, but was simply presented on a take-it-or-leave-it basis. I am also instructed that this is not a standard clause, and that such clauses have not been included in any other recent compromise agreement. Number 3. The first point to be considered is what clause 10.2 means on a proper legal interpretation. Read literally, the clause does not make sense. It is not possible to agree not to submit a request which has been made already. The sentence is presumably intended to mean either 1. That Mr. Cardin will not submit any FOIA or DPA request, i.e. the word made should be ignored, or 2. That Mr. Cardin will not pursue any request already made under FOIA or the DPA. It's not clear which of these interpretations is the one relied upon by the Council. If the latter, then the clause would have no current effect and would, in my view, be unobjectionable. Number 4. On the assumption that the Council is contending that clause 10.2 means that Mr. Cardin will not submit any FOIA or DPA request, the meaning of the provision is still unclear. In my view, there are 3 possibilities. 1. That Mr. Cardin will not submit any FOIA or DPA request to the Council in respect of the disputes which led to the agreement, or 2. that Mr. Cardin will not submit any FOIA or DPA request of any kind to the Council at any time in the future, or 3, that Mr. Cardin will not submit any FOIA or DPA request of any kind to any public body or data controller at any time in the future. Number 5. In my view, if the correct construction is that set out in paragraph 4.1 above, it is likely that this would be held to be a lawful provision. Mr. Cardin was in dispute with the Council and compromised that dispute with the benefit of legal advice. He can, in this context, agree not to pursue statutory rights which he would otherwise have. Number 6. However, the position is very different in relation to the construction set out at paragraphs 4.2 and 3 above. The rights contained in FOIA and DPA are important and fundamental rights. In relation to the former, the rights are available for the benefit of anyone. There is no requirement of standing. In relation to the latter, this is a fundamental right of an individual in relation to his or her own personal data. In my view, there is a strong argument that these are rights which cannot be subject of once and for all contractual waiver in terms such as clause 10.2. In my view, it would be contrary to public policy for such a waiver to be enforced, and a decision to seek enforcement by the Council would, in any event, be unlawful in public law. Number 7. Mr. Cardin would, in my view, be entitled to a declaration as to the legal effect of clause 10.2. In other words, a court would be asked to determine which of the various interpretations set out above is correct. If the correct interpretation is that set out at paragraph 4.2 or 3 above, then the court could also be asked to declare that it was void and of no effect. In my view, such proceedings could be brought by way of a private law claim under Part 8 of the CPR, that's the Civil Procedure Rules. On the assumption that clause 10.2 bears the interpretation set out at paragraphs 4.2 or 3 above, then in my view a claim by Mr. Cardin would have a 60% prospect of success. Number 8. In order to crystallise the dispute, my instructing solicitors should write to the Council asking them what they contend that clause 10.2 means, and stating that unless they confirm that it does not bear either of the meanings set out at paragraphs 4.2 and 3 above, Mr. Cardin will institute proceedings for appropriate declaratory relief. I would be pleased to draft such a letter. My instructing solicitors should not hesitate to contact me to discuss any matters which arise out of this advice. Hugh Tomlinson QC, Matrix Chambers, Griffin Buildings, Gray's Inn, London, WC1R5LN, 31st of May 2011. The Council failed to give any assistance by clarifying the meaning of the clause, preferring instead to cave in enigmatically. With the prospect of serious and well-founded litigation being mounted, the Council declared they did not accept the provisions within the agreement were unlawful. So they were basically saying it was all a long time ago, and they were now happy to confirm that I was not prohibited from making requests under the Freedom of Information and Data Protection Acts. I've interpreted this as the Council running away, taking their little ball with them and turning back to shout, "We were right all along anyway." And my reading of Council's opinion is, if an employer proposes a compromise agreement with an FOIDP gagging clause which seeks to prevent an employee or ex-employee from making FOIDP requests of this employer, specifically related to the historical circumstances which have led to an employee's departure, that is okay. However, if an employer proposes a compromise agreement with an FOIDP gagging clause which seeks to prevent an employee or ex-employee from making FOIDP requests of this employer or any other employer in the future, that is not okay. The fact that the agreement is signed in the presence of an independent legal advisor appears to have some bearing on the former, but not the latter. which appears to maintain that contract law trumps statutory rights. But I am not a lawyer. So if you have any comments on this, the subject of this video, they're most welcome. Okay guys, thanks for watching. Keep watching my YouTube channel and my WordPress blog for more videos coming up soon. And don't forget to like, share and subscribe. I'll be going through my back catalogue of blog posts soon, picking up some of the more interesting ones and committing them to video format and uploading them to YouTube and BitChute. Fingers crossed they survive the censor's itchy trigger finger, and look out for those videos coming soon. Okay, I'll catch you soon. Take care.